I've worked on so many interesting and memorable matters over my 19 years at the firm, but I would say hands down the most interesting things and the most fun things for me have been the many trials I've worked on. I've been fortunate to be on a number of significant trial teams over my career, and O'Melveny does still try high-stakes cases, which is somewhat unusual for a big firm these days. The first trial I worked on was a jury trial that actually took place during my first year at the firm, and most recently, just a few weeks ago, we concluded a 2-week jury trial. It was a bellwether trial. There are nearly 10,000 cases coordinated in a coordinating proceeding here in Los Angeles Superior Court, and this was the first case to be tried. And we approached it as a standalone case, as we would any other trial. We were not intending to try to win the entire coordinated proceeding. We thought about what was unique about this particular plaintiff's claim and how we would defend it and how we would respond to it. And in this particular case, our biggest successes came when we were able to expose during trial some significant credibility issues with a couple of the plaintiff's key witnesses. One was a fact witness, the plaintiff's mother, and the other was an expert, the plaintiff's general and specific causation expert, a doctor who would testify that the plaintiff had the condition he claimed he developed, which was gynecomastia, or male breast enlargement. The plaintiff's expert, this doctor, had committed to form and offer these opinions before he had ever met the plaintiff, before he had examined him, before he had reviewed his medical records. And as a result, we were able to show this expert was really biased and had not really performed an actual differential diagnosis, had not examined the plaintiff, and had not come to medically sound opinions. And we were able to expose those weaknesses during the trial. And the interesting thing about this is he had formed and committed to these opinions, notwithstanding the fact that several other doctors who had examined the plaintiff and reviewed his medical records were not able to offer the opinions that this expert had committed to, essentially sight unseen. As a result of exposing these significant credibility issues, we were able to take some pretty aggressive positions in closing statement and at the trial, including arguing to the jury that this was a frivolous lawsuit, that it was a made-up claim, and that there was no merit to the plaintiff's claims. As a result, we were able to obtain a complete defense verdict from the jury, and the client is now very well positioned to successfully defend the thousands of cases that remain in the coordinated proceeding.